June, July, August, September. And then the first 2 judges will have completed their cases. And then they start all over again. So while this is going on, and we have a very strict timeline, 9 months, and all introductory matters must be done within 3 months. After that, it goes on trial. And then the judges will do the cases. So in 3 years, we managed to dispose all the cases, the whole commercial cases. The 6,400 cases was disposed in 3 years. And in 3 years, we closed the old commercial court. So what we have is the new court, which registered cases registered in 2009, September. And because of a strict timeline, all these cases are disposed within 9 months. So in Malaysia today, all commercial cases will be disposed within 9 months in the High Court.
To deal those matters entirely through mediation. Now that is what is happening in Fiji at the moment. Most of the commercial matters where some defective products, and if the customer is not satisfied, those are going to the mediation center, because the cost of litigation in those instances are prohibitive. So the parties will not go for litigation. At the same time, the other side, the product owner or the seller or whoever also doesn't want a dissatisfied customer. So in those instances, I think it is ideal for mediation. But mediation is not the solution to all the ills of the adversarial system.
Some of these colorful expressions are a Mexican standoff, a Russian roulette, and I'll name one more, the Texas shootout. Just for those of you not familiar with these terms, I'll just very briefly try and explain them. Well, a Mexican standoff is simply a situation where the 2 shareholders or more, where the shareholders simply decide not to do anything. The shareholders have taken a position and they refuse to budge, and that's the end of it. So what does this situation lead to? This situation inevitably then leads to a situation where the company
the board of directors conducts the ultimate management of the company. It also has irrevocable competencies, the establishment of the organization, financial planning and control, appointment of persons entrusted with the management, and the preparation of the general meeting. Here what is important is that board members are obliged to serve the interests of the corporation and not only the interests of the shareholders. So it's the entire corporation, so it's a stakeholder interest that the board has to represent, not a shareholder interest. The relationship between the board and the shareholders, since the management of the company is done by the board, a shareholder has limited influence on the management and the strategy of the company. But of course, by electing the board members, the shareholder has an indirect influence. Once board members are elected, they can only be removed by a vote with the respective quorum.
There are 2 consensual solutions. That is what is called in the title kiss and make up. So you have a deadlock and you really try to convince the other party, let's do this, or maybe the increase in the capital do only by 50% of what you have planned originally. This is self-explaining, and it would be the easy way, but we are lawyers, we know it can happen differently. So the question is what happens then. Can also, this will also be a consensual solution, be that the shareholders say, well, it doesn't make sense anymore to continue our cooperation. We will split up the company, you get one part of it, I get the other, and then we split. Then the next three possibilities are have to be drafted off from the law, that's statutory regulation, and we have three possibilities according to German law. Then we also have the possibility to exclude a shareholder from the company if it is drawn in the articles of incorporation.
A shareholder may petition for a court to render judgment on the dissolution of the company if three elements are met. The first one is there should be continued serious deadlock situation. And the second element is irreparable damage has occurred or likely to occur to a company. And lastly, there should be no other alternatives to protect the interests of the shareholders other than dissolution of the company. If these three elements are met, then a shareholder can petition a court to render judgment on the dissolution of a company. This is basically the only provision in the Korean Commercial Code which is related to the deadlock situation. And then, as far as I understand, this provision itself is very, very rarely used. So basically, for the rest of 20 years, I've never seen actually my clients want to use this provision, and then I've never experienced any real situation where this provision is actually triggered and that company is dissolved based upon this provision. It means in Korea, basically there are no provision at all in the law which deals with the deadlock situation, which means deadlock is basically dealt with in the context of shareholders' agreement.
I observed that the Japanese model has several options, and those options are actually practiced in our jurisdiction. For example, a higher than majority vote can be provided in the bylaws, or such that from a mere majority, if the company is, for example, changes its purpose, a higher majority of 2/3 or even 3/4 can be required so as to protect the minority interest. In cases of dissolution, a simple majority is not enough. If it is also stipulated in the articles that a higher than majority vote is required. So I would say, just as an observation, that the issue of dissolution can really be ticklish, and that's why we are discussing this, because we would like to offer to shed some light.
That one shareholder is allowed to say, I want to terminate my status as shareholder. This is allowed according to German law, and there is no limitation from the one shareholder who wants to leave, if it's provided in the articles of incorporation. Just to tell you both sides. I know you were hinting at the other point, can the majority or then exclude one shareholder? This is much more limited. First of all, it's not, you can't just say if somebody is naughty, you exclude him.
That was an analogy.
But you have to very precisely draft the reason when you can.
But I think if that is tested in the court, I think court may look at the situation quite conservatively, meaning if it will be very hard for the court to say that one party have not exerted their best interest, the good faith effort, if they actually meet and discuss, and whatever discussion was has actually occurred, then it will be very hard. And then the commercial lawyers also think that it is not proper.
So the reality is the deadlock clause might be on the back, but might not be, used as a sword. But in any case, I would like to go into my presentations. Speaking about the deadlock situation for us, the means of the solution, we have the certain legitimate method in our Companies Act. We will say that's as a part of the minority shareholders' rights, and I think each country has each Company Act who has the varieties of the minority shareholders' rights. And I briefly explained what is the situation in Japan. We have the statutory protection for minority shareholders in the certain layers. And for example, if you have the 1/6 or more shareholders, then you can stop the short form mergers. And there's, if you have the 10% or more voting rights, or 10% or more of issued shares, then you may have the right to request for the dissolution order.